When architects and engineers face claims, there's a handful of questions that I think that they should be asking the attorneys assigned to defend them by their professional liability insurers. And I've developed this list of questions because I've been assigned by professional liability insurers many times to defend architects and engineers, but I also help architects and engineers with things that have nothing to do with insurance, like collecting fees and negotiating smart contracts. And so while this list is not exclusive, there's a few things that I think design firms should be asking their insurer-assigned lawyers at the outset of claims that they're facing. And there's a few things to understand before we get in that list. First of all is that the defense attorneys that are assigned by professional liability insurers, they typically have a high volume of cases, and it may be the case that it's a one-off representation where the defense attorney has no real expectation of coming into contact with the design firm that they're going to defend again. And so, how much of an interest do they have in, making sure that that design firm has a good experience? Perhaps not as much as they would if they were the sort of lawyer that expected to, know the principles of the design firms for years and years and help them with other matters. And, a lot of these defense attorneys are, old school. And, I don't mean that as a compliment. What I mean is that many of us, myself included, were taught as young lawyers that, litigation is formulaic. A claim is brought, and there's no attempt at talking about an early cost-efficient means of resolving the dispute. We're just going to do pleadings, and then we're going to do motions, and then we're going to do document exchange, and then depositions, and then experts, and we're just going to scorch the earth for years and years, and we'll see what happens. There is no intent. There is no, this is the way that we're going to, get in and get out of arbitration or litigation, strategically in order to, realize the most benefits for everybody. It's a little bit more of being swept along on a wave of, endless civil procedure. And so, here are four things, again, not an exclusive list, but four things that I would suggest design firms ask the attorneys who are assigned by their professional liability carriers to defend them in the event of claims. First is, what is that lawyer going to do to try to save the design firm's deductible? Now, this is different with professional liability insurance than other kinds of insurance. Professional liability insurance typically have significant deductibles. I've seen them often at $50,000. Some of my design firm clients have $250,000 deductibles, and some of the biggest firms have much more significant self-insured retentions or deductibles. And this is real money. To a smaller or mid-sized design firm, having to pay $50,000 in a deductible obligation if they're hit with a claim, that is going to have a huge impact on their operations, their profitability, their ability to hire staff, their ability to pursue the creative work that we all want them to pursue. And so if you are the principal of an architecture or engineering firm and you have been assigned defense counsel by your professional liability insurer, I would suggest that you ask that attorney, what are you going to do to try to prevent me from having to incur my deductible obligation? Because there are ways to do that. There are ways to try to steer disputes into methods of early cost-efficient dispute resolution, mediation, other forms of alternative dispute resolution. Sometimes when there is a settlement that comes out of a mediation, the deductible obligation is forgiven by the professional liability insurer. And so there is this strong interest in the owners of design firms to try to not have to blow through their entire deductible. But a lot of these professional liability insurance assigned attorneys are simply not thinking in that way because not necessarily it's their fault, but they have this high volume of cases. There is an expectation that they're going to grind out the litigation. And so I think that design firms need to be willing to advocate for themselves when it comes to not necessarily assuming at the outset of a claim that it is a foregone conclusion that they are going to have to spend all of their deductible. The second thing that I think design firms should ask the attorneys assigned by their professional liability insurers to defend them from design malpractice claims is, have you exhausted every option available to you short of going into protracted arbitration or litigation. Again, in mediation, sometimes there's this deductible forgiveness, but even if that's not the case, even if the design firm is going to incur its deductible obligation and there's absolutely nothing that they can do about it, arbitration and litigation can be a years-long, very damaging, stressful process that can take the resources of a design firm away from the projects, and have the project managers helping to answer interrogatories and collect documents and sit for depositions. And this is not good for the business interests of the design firm. And so while sometimes litigation and arbitration is inevitable, certainly that's true in cases that I handle. If I owned an architectural or engineering firm, I would be asking the attorneys assigned by my professional liability insurers whether they have exhausted every option at their disposal that makes strategic sense. Certainly not any sort of a surrender in a circumstance where it's not warranted, but have they thought creatively? Have they done everything that they can to not put the design firm in a situation where they're going to have to go through this long, painful dispute resolution process? Third, if I owned a design firm, I would be asking my defense attorney, if we have to plunge into arbitration or litigation, what is your strategy? Because a lot of these attorneys, and again, it's not necessarily their fault, but they surf this wave of civil procedure, this idea that we're going to have 18 months of fighting and it's going to be in different stages, and that's just the way that it is. If I owned a design firm, I would be saying, what is your strategy to minimize that pain? Where's the off-ramp? Are you targeting a motion to dismiss? Do you think that after you take a certain deposition, you will have the facts that you need in order to go to the other side and say, now we should talk about a negotiated resolution because I've demonstrated that we can defeat your claim? So just surfing this wave of litigation is not, in my opinion, a good strategy. When I'm involved in arbitration or litigation, I am always looking for the first strategic off-ramp to resolve the claim in a way that's favorable to my client, but also to ensure that my clients don't get swept along in this endless wave of litigation procedure. And the fourth thing that I would ask if I owned an architectural or engineering firm of the defense attorney assigned to me by my professional liability insurer is, what are you going to do to save my hard-earned business relationships? Like owners of design firms, I am a professional. I need to have clients. I need to have relationships. I work very hard at those relationships. And oftentimes, all of the parties that are involved in these protracted episodes of arbitration and litigation, these are people that got to know each other with great effort, and they've worked hard to work together. They've worked hard to, earn the job, to earn the contract, and to have some attorney who is assigned by an insurer come in and, set fire to those relationships, particularly if they haven't thought about, is that the only way, or is that the most strategic way to resolve the dispute? Raking them over the coals in depositions, giving them a hard time. That's something that I think is not in the interest of owners of design firms. And so I would certainly be asking the defense attorney, what are you going to do to save my hard-earned business relationships as we go through this arbitration or litigation, because there's no other option. Again, not an exclusive list. There are many other things that I think design firms should ask of their lawyers, but those are four important ones.